You got me. Welcome to public service this morning. It's so good to see all of you. This is our final calendar. We have 21 bills we hope to get through today, so we're going to be moving kind of fast. Members, please sign in if you've not. Everybody signed in? Oh, we got to open the roll for roll call. Clerk, please take the roll. I guess it would be good if your chairman signed in.
Madam Chair, you have 6 members present. You have a quorum.
Thank you. Members, do we have any personal orders? Yes, Chairman Eldridge.
Thank you, Madam Chair. I do have a shadow with me today, Caleb Nemeth. He's sitting right back there. If you would stand up, and if everyone would please make him welcome here.
We have a little housekeeping to do this morning. We have item number 3, which is House Bill 471, has been taken off notice. We have House Bill 7, which is item number 7, House Bill 1816, taken off notice. And we have item number 14, which is House Bill 2168. That also has been taken off notice. Now that moves us to item number 1, which is House Bill 2549 by Representative Cochran. We have a motion. There is an amendment on the bill. So Representative, would you give us your drafting code?
Yes, thank you, Chair Lady. Drafting code 014931.
Yes. Do we have a motion and a second on the amendment? If there's no objections, we'll go ahead and put this amendment on the bill and get it properly before. So all in favor, please signify by saying aye. Opposed, no. The amendment goes on the bill, and you're recognized to explain your bill.
Thank you, Chair Lady and Committee. Committee, currently on a federal level, there are restrictions on, or at least requirements, if you have any type of interest in a foreign adversary, if you're lobbying, you are required to disclose that at a federal level. There's a loophole in our nation where these same folks could represent a foreign adversary country and lobby on a state level and not have to disclose that. This bill would close that important loophole. And so it requires any individual or organization acting as an agent of a designated foreign adversary. And that we're using the federal definition of that, which is China, Russia, Iran, North Korea, Cuba, or the Maduro regime. And so if anyone is representing them, engaging in political activity, they would have to register with the Tennessee Ethics Commission, as well as the Attorney General. That's what the bill does.
Thank you for that explanation. We do have someone here to testify on this legislation. So do you want to? Representative Salinas.
Oh, I just wanted to hear from the person that signed up to testify. That's all.
We have a Stephen Puckett. Are you in the audience? I don't believe they're here, so we won't have to go out of session. Oh, there he is. So we'll go ahead and go out of session and hear from our guest first. Is that okay with everybody? We're out of session. Mr. Puckett, please identify yourself and who you're with, and you have 3 minutes.
All right. Thank you. My name is Stephen Puckett. I'm a resident of Hendersonville, Tennessee, and I speak for myself and myself only. I am in support of this legislation. As the sponsor said, this is helping bring the registration requirements, the Foreign Agent Registration Act, to the state level so that we can close that loophole. One thing I would ask of the sponsor actually, and the committee, would be to actually expand it to all foreign nations, because of the fact that a foreign ally and a foreign can become a foreign adversary very quickly. If you want to know how quickly, just get out a American history book and look up what happened on December 7th, 1941 at a little place called Pearl Harbor. So that's one of the key things that we need to understand is just because a foreign nation is an ally doesn't always mean our interests align, and there can be areas where they could be advocating for things that could be destructive to our nation that's in their interest, but on the whole still be an ally. So I do support this, but I would ask for an expansion of it. Thank you.
Members, do we have any questions for our guest? No questions? Thank you for being with us today. Do you have any comments? Oh, got to go back in session. We're back in session now. Do you have any comments?
Thank you, Chair. Sorry. Stand by. There we go. Thank you, Chair Lady. No, appreciate the testimony, and just the one question I think maybe that he brought to light on expanding it. In the bill definitions, foreign adversary means a foreign government, country, or non-government entity designated by the United States State Department. And as that list changes, if the State Department changes the list, so does the state list. And so obviously if a scenario occurs, as the witness brought up, where there's a new adversarial nation, this list adapts to that.
Thank you. I think we do have a question of Representative Salinas.
Yes, so I think here it says includes lobbyist in this. Is that correct?
You're recognized.
Yes.
Okay, so what if I am someone that is in the process of becoming a U.S. citizen or resident or have some type of legal status, and I want to be a lobbyist, but I happen to be from the country of China or any of the other countries that have been mentioned? Would that person be required to register?
You're recognized.
Thank you, Chair Lady. If you have legal status in this country and you are not representing, let's say that you are immigrating from China and you have recognized legal status in this country, as long as you're not representing the CCP, no, you're not. If you're representing, you're representing Tractor Supply as a lobbyist, even though you're immigrating from China, know that you're not required to register.
You're recognized.
What if you have TPS status and you're from Venezuela?
You're recognized.
Tell me exactly what you're referencing. Give me a more specific scenario.
TPS is a temporary level of status that is not, it's like a gray area that we have. And some countries, but the one that I've seen the most recently has been with people from Venezuela, but that's not only limited to it. There's a lot of other countries that have TPS status.
Thank you. So this bill doesn't speak to immigration status, but it speaks to who you represent. That's the ultimate. That's the question. Do you represent a foreign adversary nation or not? That's what this bill speaks to. It's not about the individual's immigration status.
I think we have some more questions by Representative McCollum.
Thank you, Chair Lady. And Leader Cochran, thank you for bringing this bill. The truth is we do have nations that would love nothing more to see us blasted into oblivion. And I think if you have somebody representing those adversarial countries, it should be disclosed that they are representing nations that want to see us dead. So thank you for bringing this piece of legislation. Look forward to supporting it, sir.
Do we have any more questions for our sponsor? Seeing none, we're ready to vote. Clerk, please open the vote. Those in favor of moving this to a full committee, please vote aye. Those opposed, no. Has every member voted? Does anyone wants to change their vote? If not, clerk, please take the vote.
Madam Chair, you have 5 ayes and 1 no.
Ayes have it, and you move on to full committee. I'm going to go, if it's okay with you, and I'm sure it will be, since you have, I think, number 19.
Oh, it might be Chairman Eldridge. Eldridge carry that.
Oh, well, I'm sorry. Okay. I know. I was just going to put you on the spot here. I got you. Bye. I was trying to do a good thing. Okay. Up next, yeah. Representative, I'm going to go a little bit out of order here because we have a representative actually in the office, in the building, in the room, and he has to be at another committee meeting. So we're going to call him up. That's item number 16, House Bill. Okay, I'm on, no, that's the other one. Okay. Okay, it's number 22, and it's House Bill 1718. And you're recognized, and you do have, let me get over to your page. It's number, not, what number on the? 22. End of the calendar. Okay, we have a motion and a second. There is an amendment on your bill. Is that correct?
Yes, ma'am.
Could you, yes, give us that drafting code.
015289.
We're going to go ahead and put that amendment on the, we have a motion, we have a second. If there's no objections, we'll go ahead and put that amendment on the bill and get it properly before us. All in favor, please say aye. Aye. Those opposed, no. The amendment goes on the bill. And Representative, you can explain your bill to us.
Thank you, Madam Chair. This bill was brought by Senator Hatcher, and they passed it in the Senate yesterday, is my understanding, with all 33 senators as co-sponsors. This legislation creates a one-year pilot program at Trousdale Turner Correctional Facility for body-worn cameras for correctional officers. This would enhance safety of not only the inmates, but also the officers, as well as increase transparency within the facilities and provide more direct workload within the courtroom. The idea for this bill came from the Senate Corrections Subcommittee, where the Trousdale DA testified regarding to difficulty of prosecution with only stationary cameras. He used a real-life example of a guard getting pulled into a cell by multiple inmates and stabbed repeatedly. If the officer were to have had a body camera, this would have given the DA a better point of view as to what happened in the cell and who exactly should prosecute and what exact charges to bring. This legislation would assist in the court decision due to instance now being on record rather than he said, she said situations. That's what this bill does.
Do I have any questions? If not, are we ready to vote? Madam Clerk, would you please open the vote? All those in favor of moving this bill to full committee, please vote aye. Those opposed, no. Has everybody voted? Does anyone wants to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 6 ayes and 0 noes.
The ayes have it, and your bill moves on to full committee.
Thank you, Madam Chair.
Okay. That brings us back to item number 2, which is House Bill 2540 by Representative McCollum.
Motion. Second.
We have a motion and a second. There's no there are amendments filed. So Representative, would you give us your drafting code?
Yes.
So which one would you like for us to consider?
Thank you, Madam Chair Lady. I have drafting code 014954.
Okay. We have a motion and a second on that amendment. We do. We're going to go ahead and with no objections, and I'll put that amendment on the bill and get it properly before. So all in favor, please signify by saying aye. Aye. Opposed, no. The amendment, the ayes have it, and the amendment goes on the bill. Representative, you're recognized to explain your bill.
Thank you, Madam Chair. Members, what House Bill 2540 does is a simple cleanup of the 2012 TEAM Act. We're calling it the TEAM Act 2.0, which focuses on practical improvements that help our agencies recruit and manage a high-quality workforce while ensuring the responsible use of state resources. The bill is a slew of cleanup measures, but addresses the following key changes to ensure the state government operates at a higher level of efficiency. One, it updates hiring practices to be faster and to make sure the highest level of applicants are reaching our agencies and are not being lost in the bureaucratic process. Two, it streamlines the disciplinary appeals process to remove months of unnecessary bureaucratic process that sets state employees apart from their peers working in the private business under at-will employment. Three, it protects the legitimate use of sick leave while addressing abuse and fraud in the current system. Item number 4 expands employee participating in disaster response by providing a new leave category under some very careful and specific guardrails. And lastly, members, it aligns outdated statutes with current compensation process for the executive branch employees. Madam Chair and members, with that, I stand ready for any questions.
We do have testimony on this legislation, so without objection, we're going to go out of session to hear from our guests. Jessica Scott, Richard Hayden, Sam Hambrook, that's fine. Just come right on up. Yep. Okay. Please, we're going to start with the young lady here, and please give us your name and who you're with, and each person will get a chance to speak, and we're going to speak for 3 minutes.
Is this on? Okay,
You're
thank you.
recognized. Yes, it is.
Thank you. Chair Lady Rudder and members of the committee, thank you for the opportunity to speak on behalf of the Tennessee State Employees Association. My name is Jessica Scott, and I'm the staff attorney for Tennessee State Employees Association. HB 2540 is a sweeping overhaul of state employment law that affects hiring, discipline, appeals, and professional standards and benefits for state employees. This is not a targeted update, it's a full restructuring. Part of the legislature eliminates the Step 3 appeals process, including the Independent Board of Appeals, which is the only external check ensuring neutrality. Without it, appeals will be managed first internally by the agency commissioner who issued the discipline, and then by DOHR. Removing this external process concentrates power and may weaken public trust in the fairness of the process. I would now like to pass the floor with permission to Dr. Haddon for his additional remarks on the current Step 3 appeals process and how it impacted him as a state employee. Further, with permission, I would also like to invite Attorney Sam Helmbrecht to share his perspective on the appeals process and his roles at Step 3 as well. Thank you.
Thank you. Up next. We'll get you my turn. Yeah, there you are.
Good morning, committee members. My name is Dr. Richard Haddon. I proudly served the state of Tennessee as a pharmacist investigator for 24 years. Despite my records of service, I was terminated by the Department of Health as a preferred service employee. I had the right to appeal through the appeals process afforded under the TEAM Act of 2012. Step 3 allowed me to present my case before an impartial panel comprising 3 panel members, an administrative judge, attorneys representing the Department of Health, and me. I was given an impartial external review, which was not conducted by the department that accused me of wrongdoing and imposed the discipline. With help from counsel of the Tennessee State Employee Association, I was able to present the evidence and full facts of my case. After hearing the testimony and reviewing the evidence, the panel unanimously determined that my termination was unwarranted. My termination was overturned. I was awarded the back pay, and my employment was ordered to be reinstated. The Step 3 process did exactly what it was designed to do. It safeguarded my employment by allowing my right as an independent review of the disciplinary action. Without the independent review, The termination of a longtime state employee would never have been corrected. I respectfully ask that you preserve step 3, appeal rights for Tennessee state employees, so that fairness, accountability, transparency, and due process remain part of our disciplinary safeguards. I'll now turn it over to Attorney Sam Hembrich for further comments. Thank you.
You're recognized.
Thank you, Madam Chair, committee members. My name is Sam Helmbrecht. I'm a local attorney here in Nashville. I've been practicing administrative law for the last 20 years here in town. I've been asked here to tell you my experience with the step 3 process. Over the past several years, I've handled a total of 35 cases. And in 24 of those cases, I've been asked to take it to a step 3 hearing. In all but one of those cases, it involved a separation of state from state service. And in 14 of those 24 cases, the employee has been reinstated. 2 of those cases are currently pending. 1 is in Chancery Court. That's a reinstatement rate of 64% in my experience. And those cases run the gambit from Department of Safety all the way to the Department of Mental Health and Substance Abuse Services. I typically find these employees in dire straits, and that's not an exaggeration. They have lost their income, they have lost their health insurance, and they have typically worked for the state for a significant period of time. And so they've lost any kind of referral when they're trying to find a new job. Typically in these hearings, the issue relates to 2 things: a breakdown in either the training or in the investigative and disciplinary process. And I only mention that because I think it's important, because the governor has picked very good board members who are usually attorneys in the field of employment law or HR professionals. And during the step 3 process and at the hearing, both sides, the former employee and the state, put evidence together to these board members. And during deliberations, which is open to both sides, these value professionals on the board provide advice and recommendations not only to the employee, but to the state agency to improve their process and services that they provide to the Tennessee citizens. So I think it's an invaluable process on both sides. This process is shortened. It's 120 days or 140 days, which is difficult to get a lot done in that time, but mainly we can do it. But as I mentioned earlier, there has been occasions where we couldn't get the case heard. And so that we think that a streamlining of the process of the actual hearing can be done, whereas each side is limited to a number of witnesses. There is more virtual hearings rather than in person. That will cut down travel time. We have board members from Knoxville, Jackson, Chattanooga. I'm from East Tennessee originally. So those drives can add a significant time commitment to the board members, where if it's all virtual, rather than traveling for 6 hours, they can pop onto their computer in their office and have the hearing. The appeals process from the board is convoluted if there is not a step 3. You would have to issue a writ of certiorari, because there would not be a direct appeal from step 2 to the Chancery Court. In the Chancery Court appeals, they usually do not hear new testimony. They rely upon the record developed below at the agency level. If we don't have the step 3 hearing where a transcript of the proceedings has been developed, legal issues have been developed and framed by the attorneys for both sides, and the ALJ has made legal rulings, it'd be very difficult for the Chancery Court to hear a writ of certiorari without any kind of record, based upon just a step 2 written decision. That's all I have, and I'm open, of course, to take any questions, Madam Chair.
We do have a question from Representative Salinas.
Thank you. And I also have some questions for legal before we go into session, just getting that. My first question, I think I have a question for each one of y'all. What's your name?
Oh, excuse me.
Ms. Scott.
Yes.
Okay. Thank you. I'm still trying to wrap my head around the process itself. Can you describe the current process under current law? What is that like?
Yes, ma'am. So the way that it currently works, if a preferred service employee has met the probationary period and they have been demoted, suspended, or terminated, they are allowed to appeal that to what's called a step one. At step one, it is the state agency commissioner, or what's called a commissioner's designee, that conducts that hearing. Under the way that the current statute states, there is a representative for the employee that's allowed to be present only if there's an additional party that is allowed to be present for the state agency side. At that, they're not allowed to ask questions or to speak. They're just there simply for support. They then present their proof as far as from the state agency's perspective, and then the employee is allowed to ask questions or make a statement. After that period is done, there's a written decision that is issued, and then either party, the state or the employee, is allowed to appeal to step two. Step two is an internal process that's entirely written. The only additional information that's provided at step two is a written statement on behalf of the employee. And then at that point, when a decision has been issued, you are then allowed, either party is allowed to appeal to the step three, which is where we have the description that Attorney Sam Helmbrecht just provided, where you have a hearing in front of an administrative law judge and a 3-panel system. And then you have an attorney for the employee if the employee has representation or they're there on behalf of themselves, or you have an attorney for the state, sometimes one, maybe two.
Okay, thank you. And then I guess this second question is for the lawyer. Here, the lawyer on the panel, not the
The
legal.
lawyer on the corner, you're up.
So what needs to trademark and have that as a law firm? Can you explain what this proposal regarding kind of the process, the new process, because it's changing the process, what the difference from what we have currently and what is being proposed?
You're recognized.
Thank you, Madam Chair. I can't speak to the entire process at step one and step two, but at step three, I think it's the elimination of step three. So therefore, after the step two, the employee would not have an opportunity to appeal to a step three to have their hearing before that panel of 3 board members. Again, those board members are usually attorneys or HR professionals throughout the state that would take evidence and hear the case. So it's my understanding that after step two, the case would cease, and that would be the end. Now, it's important to keep in mind that from day one after termination, according to the Presley case in the TEAM Act, the employee is no longer an employee. So the status is as an ex-employee. So they're not in state service throughout this appeals process. So then after step one and step two, they would not have a right to appeal to the Board of Appeals. That's my understanding of what would change in this bill.
Okay, thank you. And then my question for the doctor would be, what would your case, what would have you think the result would have been without that unanimous step three decision that you got if that was eliminated?
You're recognized.
Thank you. I think that step three was very, very important in my case because as Ms. Scott said about step one is I won. The representative for the commission, their representative gives the recommendation and they recommended to reinstill my employment. Step one, for that representative, they can only recommend. It's still up to the commissioner. But so in a lot of cases, the commissioner takes the recommendation of their representative that heard step one appeal. In my case, it didn't. So then through TSEA, who was there, supporting my efforts, then step two, then I submitted the letter and that goes to the Department of Human Resources. So then they're the ones that review and make the decision in step two. And so then they come back with their decision. And in my case, step two was denied. HR upheld the termination, and then we filed for step 3. And it was a little bit of a wait before we had the hearing, but we did do the hearing remotely via the Zoom and the computer. So the 3 board members, didn't have to travel. So we did it all, via Zoom. And it was just basically fair to say my side of the story, hear the departments, and let that panel, decide whether that termination was necessary. And so, like I said, unanimously, they just felt that the department didn't have the right for that, and they granted my job back and back pay, and it was very, very important to me.
Thank you. And my questions for legal, I don't know if you want.
Now, anyone else have any for our guest? Okay, we're going to legal.
When was there currently the process that we have currently, when was that enacted into law?
Thank you, Matt Money from legal. My recollection is that the TEAM Act was initially came into place in 2012. Is that right? I think that's right, 2012.
Okay, thank you.
Do we have any more questions? Yes, we do. Representative Warner.
Thank you, Madam Chair. And to the young lady on the end, I apologize, I forgot your name. Has the association tried to work with the sponsor on an amended bill that maybe we could all get to a happy medium?
You're recognized.
Thank you. And this may be a better question for my colleague, Evan Sudith, as he's been very paramount in those negotiations. But it's my understanding that we have been working, and we would like to also thank Leader Lambert for his efforts that have been made. I'm just not sure if we are there yet to a place to where there has been something that both sides have had a chance to look at and vet and have been able to review.
Thank you. One last.
Sure.
Thank you, Madam Chair, again. And one last question. It's my understanding that may be another amendment coming. If this bill was to move out of this committee, do you feel like the association can get on a common ground here? I mean, what seems to, I guess, what's the biggest holdup? Is it to step 3 that we're discussing here?
You're recognized.
Yes, sir.
Okay. Thank you, ma'am.
Do we have any more questions for our guests? If not, we do have one more person to recognize, and we appreciate you being here with us today. Thank you so much. Next, we have Eric Mayo. Good morning.
Good morning, Chair Lady.
State your name and who you're with, and you have 3 minutes.
Thank you, Chair Lady. I appreciate this committee and the conversations we've had. I think the sponsor presented clearly, and it sounds like you guys have some questions for me. I'll just say, just to give some context for how we got to this point, we at the department spent quite a lot of time kind of going line by line through the TEAM Act and the surrounding sections of code just to see what areas we could find that we could improve on in the last year of the administration, where we could find efficiencies and savings and truly have state government work better for the taxpayer and for our employees as well. And we may not be in agreement on some of the policy ideas that the previous guest spoke on, but I'm happy to answer questions on those. And I will just go ahead and say clearly, we are working as hard as we can to come to a compromise. And to speak to Representative Warner's point, there is an amendment that we are hopefully continue to work with them on if we proceed from today, and would love to get to a place where everyone is comfortable. So I will answer any questions. I thought that might be more effective than me rambling on. So thank you.
Representative Salinas.
I haven't seen any amendment other than the ones that are here. Is step 3 secured in the amendment, in the future amendment, I guess, because we haven't seen anything?
You're recognized.
Thank you, Representative. I think the question of if step 3 being secured is the direct answer is no, ma'am. I do think we are looking, though, at the appeals process as a whole. One thing that the association has brought to our attention that they feel like is very important is that the employee is able to have representation throughout that process. That's something that's very much on the table. We want to open up the front of that process so that the employee has access to as much information as possible and resources as possible to get to a place where everyone is comfortable. Step 3 comes with quite a bit of burden for state agencies, cost and time, attorney time. And what we're seeing is a process that a significant number of the folks who file for a Step 3 appeal never actually have the appeal. There are very few that actually get heard at the end of the year or at the end of the cycle, rather. So what we're looking for is a process that is more efficient for the agency and we can have clarity sooner. One thing that was also brought to our attention that's very important is access to an efficient court process if someone wants to go to Chancery Court after the appeals process is complete. And we're looking at some creative solutions to help move that ball forward in a way that would allow for a quicker process for employees in that venue.
Right. So step 3 is not secured in potential future amendments.
Yes, ma'am.
Okay.
Do we have any more questions for our guests? If not, we'll go back into session and thank you for being here. Do we have any questions for our sponsor? Representative Warner.
Thank you, Madam Chair. And Mr. Sponsor, again, thank you for the bill. Is it in your opinion that we can get to a common ground, or maybe the two sides here can get to a common ground if this bill moves forward to full committee?
You're recognized.
Thank you, Chair Lady. And to my dear friend from Marshall County, I certainly hope that we can get to a point where this bill is palatable for all parties involved.
Representative Salinas.
Yeah. There are parts of this bill, I kind of have issues with calling it cleanup bill that has 22 sections to it. There are several parts that I agree with that I think are not problematic at all. Why just bring one bill instead of splitting it up into several bills?
You're recognized.
Thank you, Madam Chair Lady, and to my friend from Shelby County. Well, to start with efficiency, one bill to clean up state government, I think, is a far more effective manner than having multiple bills to address it when we can do it on one fell swoop. State government's big. There's a lot of bloat within it, and I think anything we can do to streamline it, modernize it, and make it more efficient and effective for the constituents, our constituents, we should be doing that. So that's why we have one bill.
You're recognized. I didn't know for sure if you had another question.
Yeah, no, I mean, I think for me, it's not efficient because some of the parts that I think are good and should be made into law are going to be prohibited from me voting for this because it addresses so many aspects. So I would consider this not an efficient way of doing it because we're holding up good parts of the bill. Like I said, there are good parts that I agree with. And I don't have any questions.
Any more questions? No more questions? I think we're ready to vote. Madam Clerk, please open the vote. All in favor of moving this bill to full committee, please signify by saying aye. Please vote aye, or are those opposed? No. Has every member voted? Does any member want to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 4 ayes, 1 no, and 1 present not voting.
Your bill moves on to full committee. Next up, we have item number 4, which is House Bill 2114 by Chairman Crawford. Do we have a motion and a second? We do. There is an amendment filed on this bill. Chairman, could you please give us that drafting code?
It is 15041.
We've got a motion and a second. If there's no objections, let's go ahead and put that amendment on the bill and get it properly before us. All in favor, please signify by saying aye. Those opposed, no. The ayes have it. Your bill is in the, the amendment is on the bill. Please explain your bill for us.
Thank you, Madam Chair Lady. Thank you, committee. Y'all really look good today.
Well, that's good to know. We try.
No, this is a very, very, very simple bill. This was put together with the Tennessee Municipal League and also representatives of the Tennessee Press. And we were trying to maybe do some notice changes and things, but we are now asking that it go to TASER and let them study it and come back with a report to the chairman of the committees. So that's really all it does. I'll be glad to answer any questions, but it's just a TASER bill.
We do have testimony on this piece of legislation, so without objections, we're going to go out of session and hear from our guest, Mark Millsap. Welcome to our committee. And
thank you.
Just give us your name and who you're with.
Yes, ma'am. My name is Mark Millsap. I'm the executive director of the Tennessee.
Excuse me, I don't mean to interrupt, but you'll have 3 minutes.
Yes, ma'am. Executive director of the Tennessee Press Association, representing 131 newspapers throughout Tennessee. And when I say newspapers, I mean print and online only newspapers. So we look forward, and when I say we, TPA and newspaper publishers in Tennessee, look forward to being part of the study and discussing public notices and how people still read and use newspapers to get their news and information every single day. They do this by reading the print version and reading the online version as well. We embrace as an industry online because we know readers are both print and online. So really, I'm here today just to answer any questions about newspapers, their growing readership, and public notices the way we're doing them right now in the state.
Do we have any questions for our guests? Seeing none, thank you very much. We'll go back into session.
Madam Chair, I'll renew my motion.
Do we have any questions? Yes, Representative McCalman.
Thank you, Chair Lady. Move previous question.
Previous question's been called. Please open the vote. All in favor of this bill, please signify by saying aye. Those opposed, no. Has everybody voted? Does anyone want to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 6 ayes and 0 noes.
The ayes have it, and you move on to full committee.
Thank you, Madam Chair Lady. Thank you, committee.
Chairman Crawford also has item number 5, and that is House Bill 2117. We have a motion, we have a second, and there's no amendments on this bill. So you're recognized to explain your bill.
Thank you, Madam Chair Lady. This is another very simple bill. It increases from 5% to 10% the employee's contribution to the Tennessee Consolidated Retirement System. What this would do, if you have 10 years of service, it would allow you to go for that 5 to 10, and it has nothing to do with the insurance. The insurance was part of this bill at one time, but I worked with the treasurer and we come up with something that will bring us all to the same place, but it does not affect insurance in any way. This is just for the retirement.
Do we have any questions for our sponsor? We do. Representative Warner?
Thank you, Madam Chair, and thank you, sponsor. What the 10 years? Why not 5 years, or why not after the first year?
You're recognized.
Thank you, Madam Chair Lady. To be honest, Representative Warner, when I met with the speaker to try to fix this bill, he liked the 10-year mark, so that's what I put in there. No specific reason other than he wanted it.
You're right. Another question? Are you recognized?
Just follow. Yeah, thank you. That's probably pretty good advice to follow what he says.
Do we have any more questions? If not, we're ready to vote. Madam Clerk, please open the vote. All in favor of this bill moving to full committee, please signify by voting yes, or opposed no. Has every member voted? Does anyone want to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 5 ayes and 1 present not voting.
And your bill is going to full committee. Ayes have it. Okay, we're going to go out of order again and take up item number 16, House Bill 1696 by Representative McCallum. Motion and a second. Let me get to 16. We have a motion and a second. There is an amendment filed. Representative, would you please give us that amendment?
Yes, Madam Chair. I have drafting code 014675.
That's correct. Do we have a motion and a second on this amendment? If there's no objections, we'll go ahead and put this amendment on the bill to get it properly before us. All in favor, please signify by saying aye. Aye. Those opposed, no. The amendment goes on the bill, and Representative, you're recognized to explain your bill.
Thank you, Madam Chair and members. I will be brief. What this bill does is two things. One, it decreases the amount of time that each department and agency in the state have to reimburse any vendors that they are on contract with from 45 days to 30 days, much like we are as private citizens. We operate on a 30-day net. Figure this is a goose and gander kind of analogy here. Secondly, it will require a report to be filed from each department and agency to the General Assembly on the September 15th, I believe, as amended. Basically providing transparency with regards to how many late payments we've made as a state and how much statutory interest payments have been made on those late payments due to paying late. So with that, I stand ready for any questions.
Do we have any questions for our sponsor? Seeing none, we're ready to vote. So, Madam Clerk, please open the vote. All in favor, please signify by saying aye. Those opposed, no. Has every member voted? Does anyone wish to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 5 ayes and 1 present not voting.
The ayes have it, and your bill moves on to full committee. Next up is item number 6, which is House Bill 1698 by Representative Rudd. Rudd, come on up. We've got a motion and a second. There is an amendment. Could you give us your drafting code, please?
Madam Chairman, 13007.
Do we have a motion and a second on the amendment? We do. If there's no objections, we're going to go ahead and put this amendment on the bill and get it properly before us. All in favor, please signify by saying aye. Aye. Opposed, no. The ayes have it, and the amendment goes on the bill. And Representative, you're recognized to explain your bill.
Thank you. I'm sure I've been here 10 years, going on 10 years now, and we have a severe issue up here. And I think most of you that have run legislation knows we are on a continuous basis each session, each year, provided false information from the executive branch, especially to fiscal review, to kill bills. And we need honesty. 36 other states have passed on our legislation. And we currently have a law on the books, but it's very, very weak. It's never used. In my 10 years, I don't know if there's ever been anyone put under oath in a committee, because you have to subpoena them. You have to call them. It's a very complicated process. What this bill does is it ensures veracity and testimony. The bill authorizes committee chairs to place executive branch employees under oath, creating a legal obligation for truthfulness during the legislative testimony. It also provides physical integrity by requiring that affidavits for documentation related to fiscal notes and the bills ensure the financial impact of those proposed laws are calculated and used accurately. And by the way, the existing law does not cover physical review. Uniform accountability under the law. Intentional false statements would be classified as a Class C misdemeanor. And if someone is found to have violated that, it's ultimately up to the speakers whether there's any prosecution or punishment. Next up is formal. It also provides a formal referral process. The legislation outlines a clear path for accountability. If a committee chair or physical review director suspects false information that has been provided, they can have those speakers put under oath. So not everybody's under oath. It's up to the will of the chair of the committee. If they feel someone from the executive branch is giving false information, they can have them repeat it under oath. Right now, chair does not have that authority. Strengthening the checks and balances measure reinforces that the General Assembly has oversight of the executive branch instead of them having oversight over us. The ultimate decisions rest with the committee chairs and the speakers as to whether to pursue charges. Keep in mind, similar legislation, again, has been passed in 36 states. I realize it's hard to take a stand against the executive branch. However, this legislation is needed to ensure that members of the legislature and physical review have accurate information from which to make a decision. This streamlines the process and gives the committee chairs and the speakers more power to ensure that this process happens, as well as physical review. We have, as legislators, we have to make a decision. Are we on the side of the bureaucracy or are we on the side of the citizen? We have to have accurate information to protect our citizens. So I ask you to vote your conscience, and I ask you to support this bill. Thank you.
Do we have any questions for our sponsor? Okay, Representative Warner.
Thank you, Madam Chair, and thank you, sponsor, for the bill. This is much needed. Would this require just the physical review committee or any committee or any department of the state to go under oath?
You're recognized.
Review wouldn't they, but people sending information would. Right now, it's just covering, this particular bill covers the executive branch. I didn't want to bite off more than I can chew, and that's biting off a lot to defeat the executive branch on anything. Of course, they don't want to be placed under oath. They don't want to be withheld or put in any jeopardy of providing information. Sometimes it's not even the speakers before committee. It may have been they were provided false information. But this would help ensure that we do have more accurate information. Right now, there's no safeguards for that at all because they, again, are not put under oath.
Follow up.
Please. Yeah.
You're recognized.
Thank you. And I think it would be nice if we could amend your bill where every department that testifies against the people of this state, because that's what they're doing when we bring legislation from our districts. They're testifying against, they're trying to silence the voices of Tennesseans, that every department go under oath. So thank you for the bill. I'll be supporting.
Representative Rudd.
Yes, I would like to also put either next, if this should pass and go into law at one point, I'd also like to put all the government employees, including legislatives, such as 3 constitutional officers, under oath as well, because we have a severe problem with, like I said, more of a physical review than we do our committees, the figures. An example, Representative Warner, a couple of years ago, I had the Department of Safety, I had a bill that would ask to put an initial on the back of a license so that certain decorated military veterans could park free at our 4 airports. And they opposed that and said it would cost like $800,000 or something. The very next week, Representative Doggett came forward and he wanted to do something and put an initial on the back of it, and it was not significant. So we need right information to deal with. And I've had other departments over my 9+ years come before committee and especially physical review and provide false information. I had a Department of Government just 3 weeks ago provide an absolutely outrageous physical note that had nothing to do with the bill. And I met with physical review and they got that trimmed way, 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 way down because they were provided false information from a department. And he acknowledged that. So it's something, it's very hard to do because they're the only departments that have the information physical review needs to they provide information on what it's going to cost to implement a bill. And if they're able to provide any information to kill a bill, there's no way for us in most cases to prove it's false. So we need a legislation like this. The legislation that's in place now, like I said, that's never used, would apply to everyone, lobbyists and everyone's involved. But like I said, it's never used because you have to subpoena them. It's usually after the fact. You don't know if they're going to be telling false information. This would allow the chairs of the committees on the spot to put them under oath. So that'd be this, it's a streamlined version of what we have now for some departments. But I agree, it should be widened.
Representative Salinas.
Yeah, so this is my first term, and I have been, I've seen what you just mentioned of, I'm like, this bill and this bill have 2 words difference, yet the fiscal note is drastically different. And oftentimes it doesn't make sense to me. So I really like your piece of legislation. I do think that it could be expanded a little, but I understand that sometimes that has challenges. So I think this is a really good starting point. And I think our founding fathers would support something like this because it keeps our checks and balances and makes sure that we have equal power, not more power, equal power to the other branches. So thank you for bringing this legislation.
Follow up? Any more questions?
Again, as I've said, this is so incredibly warranted. We can put more teeth into it at a later date. Right now, I've got it. The legislation that's never used that's in place now, I believe, is a $5,000 fine and much more stiffer penalties. But what use is it if it's never used and it's so cumbersome to put in place? This does streamline it and give, again, the chair the authority on the spot to put them under oath, as well as the speakers will decide whether, if there's any wrongdoing, whether it was justified to pursue any punishment.
Do we have any more questions for our guests? If not, we're ready to vote. Madam Clerk, would you please open the vote? All in favor of moving this bill to a full committee, please vote aye. Those opposed, no. Has everyone voted? Does anyone wish to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 6 ayes and 0 noes.
The ayes have it, and your bill moves on to full committee.
Madam Chairman, may I say a word? Thank you.
You may, sure.
If any of the stakeholders have any complaints, none of them have really contacted me other than tell me it's red flagged. I urge them to come to me and maybe we can work out something, but I think it's so simplified now, it's a good first step. But thank you, committee.
Thank you. Now we're on item number 8, which is House Bill 2010 by Representative Littleton. We have a motion. We've got a second. There is an amendment on your bill. And could you give me that code?
Yes, ma'am. It is 15023.
That's correct. Do we have a motion and a second? And we do. If there's no objections, we're going to go ahead and put this amendment on the bill to get it in the properly before. So all in favor, please signify by saying aye. Aye. Opposed, no. The ayes have it, and the amendment goes on your bill, and you're recognized to explain your bill.
Thank you, Madam Chair. This bill requires a tire manufacturer or supplier responding to the state solicitation for bids for the supply of tires to clearly identify and designate which tires offered have been produced and manufactured with indirect processed zinc oxide or indirect processed zinc oxide, and requires the designation to be included on a submitted price list or buying guide and included on all documents submitted as a part of the procurement process. Requires the information to be made or submitted in manner prescribed or approved by the Chief Procurement Officer.
Thank you for that explanation. And we do have someone here to give testimony. So we're going to go out of session and ask Mr. Jason Hale to come forward. Welcome, Mr. Hale, to our committee. Please give us your name and who you're with.
Yeah, sure. Thank you, Madam Chair.
3 minutes.
3 minutes. Thank you. Thank you, Madam Chair. Thank you, members of the committee. I'm Jason Hale. I'm with Hankook Tire North America. Excuse me. Globally, we're the 7th largest tire maker in the world. Here in Tennessee, we've invested several $1 billion in production facilities in Clarksville, and we currently employ about 1,200 people, make about 5 million tires in Tennessee currently. We've also made another multi-billion-dollar investment in a second facility right beside the first one. When it opens in a few months, we'll add 1,000 more jobs to Clarksville and double our production of tires made right here in Tennessee. Regarding this bill, Madam Chair and members of the committee, it came as a surprise to us. We were not involved in it and only recently learned that a non-tire maker was pushing for a new set of requirements for tire makers when those tire makers try to sell to the state. On the face of the bill, we don't know what problem it's trying to solve. It certainly doesn't address anything going on in the tire industry. It's not an issue being raised by our National Trade Association. It's not an administration bill where they're asking for this new requirement. It raises more questions than it provides answers. So who is this constituency designed to serve? The best I can tell from what I've gathered is it's one constituency and one only. It's the company that sells the ingredient for the process that they want to steer the state towards purchasing. Specifically, our company has concerns. Number one, on the disclosure piece, I've talked to our VP of sales in this particular space, a 40-year industry, and asked him, has a fleet manager, commercial or government, ever asked you for a disclosure of the zinc oxide process? In 40 years, not one question. It's just not something fleet managers are interested in. And so we think, why enlarge a state government form with something that isn't useful for the purchaser here? When we would be in favor of reducing the size of government forms. But you might say, well, okay, well, even if it's not useful, what is the harm? Well, specifically, our view is what this bill requires is for tire makers to start disclosing tire chemistry as it pertains to make and model of tires. For those that are not aware, tire recipes are considered kind of the secret sauce of the industry on which a lot of competition is based. We think this goes down a road that we shouldn't be going down in terms of forcing companies to publicly disclose this, as these are all publicly available documents. Secondly, if the end game is ultimately to try to steer the state to purchasing a certain kind of tire with this ingredient, it is reducing our choice and our ability to make tires according to the needs of the fleet and the business and the customer that we need. It also would force us to use a more expensive tire process. What does that mean? Rising costs for us, possible increased prices of our tires, and ultimately for the fleet, the state fleet, that would be more dollars paid by the taxpayers. Our view is if it's not good for businesses like ours and it's not good for the taxpayers, we don't think it makes sense to move forward with it. I'm happy to answer any questions.
We do have some questions. So Representative Warner.
Thank you, Madam Chair. Can you tell me, without giving away, I guess, your trade secrets, what does the zinc oxide do in a tire? Yeah.
You're recognized. You're recognized.
Sorry,
That's
Madam
fine.
Chair.
You're recognized.
At a very high level, Representative Warner, the metal is used inside the tire composition to improve durability primarily. So tires being made out of rubber, they actually degrade faster without the addition of zinc and zinc oxide. So it's to give it a longer life. It's to extend that and also extend its durability.
You're recognized.
Yeah. How many other companies in Tennessee or around produce this other product or what we're trying to ban?
You're recognized.
Thank you. In terms of Nokian has a production facility. I obviously cannot speak for Nokian, and I'm not sure. I honestly don't know what processes they use in terms of local production, if that was your question.
Do we have any more questions? If not, we thank you for being with us today. We'll go back into session. Do we have any questions for our sponsor? Yes. I'm going to go to Langford this time first. Representative Langford.
Thank you, Madam Chair. Sponsor, can you tell me what problem this is trying to fix currently?
You're recognized.
Thank you, Madam Chair. We're just trying to get a list of the ingredients that are in a tire. When I go buy lotion at wherever I buy my lotion or wherever, everything that we purchase has ingredients on it. And so it's like we were just asking them, we're not asking for the recipe. You know, everybody has secret recipes. And I've got a couple I don't want to give out either. We're just asking for them to put label the ingredients that are in the tires.
Follow up?
And
yeah. Go ahead. Do you have another?
We did, another company did ask to meet, and we did meet with them, but and we would have been glad to have met with this group, but they did not ask us. But we did meet with some other tire company, or one more tire company, and they're fine with the bill.
Follow up.
Do we need a law currently to do this, or is this something that the CPO could do themselves and ask for this information?
You're recognized.
Sorry.
You're
I should know
fine.
better
You're
than
fine.
that.
We're just trying to
We're-
do our thing.
Thank you, Madam Chair. We're just asking them to put their ingredients, all of them, to put their ingredients on the tires.
But do we need a law?
You're recognized.
Thank you. Do we need a law to do that, or is that something they can already do?
You're recognized.
We're just asking, I guess we do need a law that they all put the ingredients on their tires. I think, like, go back to my lotion. I think it's a law already that they have to put their ingredients on. If you buy food in the store, the ingredients are supposed to be on there. So these are tires that are on the road every day, and we would just like to look at their ingredients.
Any more questions, Representative? Okay, we're going to move to, Representative Warner, did you have a question? Yes, Representative Warner.
Thank you, Madam Chair. Yeah, and I'm having a hard time understanding what's the deal. I can understand with your lotion or what we're eating that's going on our bodies, but these tires are hitting nothing but the road. And I buy a lot of tires as a construction company owner and have several company trucks. And I definitely don't want to do anything that runs the cost up on small business. It's just, I'm having a hard time understanding why this is needed or really what we're doing here.
You recognize Representative Littleton.
Thank you, Madam Chair. This bill there's already a list of boxes that they fill out. So this bill is simply reporting a bill that would add 2 additional boxes that they would have to check. The other 99 boxes are already required on a procurement form for the tire manufacturers that produce in the state of Tennessee. It does not require them to change any of the way the tires are made. It simply gives the Tennessee Chief Procurement Officer more information when determining who to procure tires with.
Follow up?
Yeah. So the way you kind of presented that to us, it kind of makes it look like if these companies are not doing this or not meeting, the boxes that need to be checked, we could limit competition in the state when it comes to bidding our tires. So I just got a little bit of concern with that. I still don't fully understand. I'm having a hard time gripping why we're taking stuff up like this right now. But
Representative Littleton, they're getting queued up here. You're just Representative Littleton. Do you have a follow-up? McCown.
Thank you, Madam Chair. And Chair Lady Littleton, would you just kind of a 2-part for you? Would you define this as just a disclosure bill?
Representative Littleton.
Absolutely.
You're recognized, Representative
Thank
McCown.
you, Chair Lady. And so from a tire perspective, I think it would be a fair, I think it would be fair to have that disclosure. The zinc, as the guest testified, is adding to the durability of these tires. I think if we have a company, and not saying that there's any company currently utilizing a substandard quality of zinc in their tires, I think it would be good for those of us, particularly in the state if we're using tires, to know that we're having the best quality of zinc oxide in those tires so that we're not getting substandard, therefore creating a safety situation on the roads as it degrades. Would that be safe to say?
You're recognized.
Thank you, Madam Chair. It would. Could I say one more thing too?
You may.
Okay, this legislation is a simple right-to-know legislation which requires all suppliers of tires of the state of Tennessee to identify which tires are produced with 100% French or indirect processed zinc oxide or blended or direct processed zinc oxide. It just simply tells us what are in the tires. And there's already a place there. They just have to check 2 boxes. There's 99 other boxes, and they just have to check 2 others.
Okay. Do we have any more questions? Yes. Representative Langford.
Thank you, Madam Chair. Is this something that the procurement office is asking for? Would they find value in the information?
Representative
Thank you. I think so.
Do we have any more questions for our sponsor? Seeing none, I think, we do. Okay. Okay. Well, okay. we're going to go ahead and vote now. So, Madam Clerk, would you please open the board for vote? All those in favor of moving this piece of legislation to full committee, please signify by voting aye. Those opposed, no. Has everyone voted? Does anyone want to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 3 ayes and 3 noes.
Yeah. I'm sorry, but your bill fails. Next up is item number 9, which is House Bill 1920 by Representative Miller. Do we have a motion and a second? We have a motion, and do we have a second? There are amendments filed on this bill. Representative, would you please give us your drafting code?
Thank you, Madam Chair, members of the committee, and good morning. Drafting code 015620.
Do we have a motion and a second on this amendment? We do. If there's no objections, we're going to go ahead and put this amendment on the bill and get it in properly before us. All in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is going on the bill. And Representative, you're recognized to explain your bill.
Thank you, Madam Chair Later. It's pretty self-explanatory. Tennessee Code annotated. It's amended by deleting the language $1,250 and substituting $2,800. That's the gist of the bill.
Okay, thank you, sir. Do we have any questions for our sponsor? We have no questions, so we're ready to vote. Madam Clerk, please open the vote. All in favor, please vote aye. Those opposed, no. Has everybody voted? Does anyone want to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 4 ayes and 1 present not voting.
The ayes have it, and your bill moves on to full committee. Next up, we have item number 10, House Bill 2436 by Representative McKenzie. We have a motion. Do we have a second? There are no amendments filed, so Representative, please explain your bill for us.
Thank you, Madam Chair and Committee. The impetus for House Bill 2436 was the tragic killing of Davion St. Germain, who was shot at his house during a SWAT raid in the wee hours of the morning last year. When the SWAT team made contact inside his house to take him into custody, shots were fired by the deputies and he was pronounced dead on the scene. Problem is, we don't know what happened in that house because none of the officers were wearing body cameras. What this legislation does, it seeks to ensure that something like this doesn't happen again and requires the law enforcement agencies to adopt a baseline policy, a floor, if you would say, in terms of written policies, in terms of them using their body cameras. Anecdotally, the sheriff of Knox County actually changed his mind shortly after that, and now in those types of situations, they wear their body cameras. So what this legislation does is require each policy to include a guideline on the use of body cameras to ensure the cameras are worn in a location and a manner that maximizes the footage captured. It requires the standards for when these cameras go off and go on, and lists a requirement to notify the subjects as soon as reasonably possible that they're being recorded. Of the county and municipal entities, 60% of them already use body cameras. And what this bill does is deals with them, not the other. It doesn't require entities that don't wear body cameras to start wearing them. But if they do, it sets that floor, that minimum times that they to wear them. With that, I'll stand here ready for questions.
Do we have any questions for our sponsor? Seeing none, are we ready to vote? Madam Clerk, please open the vote. All in favor of this legislation moving forward to full committee, please signify by voting aye. Those opposed, no. Madam Clerk, please take the vote.
Madam Chair, you have 5 ayes and 0 noes.
Your bill, the ayes have it, and your bill moves on to full committee.
Thank you, Madam Chair and committee.
Next up, we have item number 11, which is House Bill 2462 by Representative Pearson. I don't see him in the room, so we're going to move this to the Hill. Okay. Next up, we have House Bill 12, which is item number 12, which is House Bill 2616 by Representative Moon, who has been waiting patiently.
No.
And there is an amendment filed. So Representative, would you please give us that drafting code?
Yes, Madam Chair Lady, it's Amendment 14259.
Do we have a motion and a second on this amendment? We do. If there's no objections, we're going to go ahead and put this amendment on the bill to get it properly before us. All in favor, please signify by saying aye. Aye. Opposed, no. The ayes have it, and the amendment's on the bill. You're recognized to explain your bill.
Thank you, Madam Chair Lady and members. I'm running this bill for Representative Hill. As amended, House Bill 2616 allows local government job applicants to request their application remain confidential. The confidentiality applies only to director level staffs. For example, chief financial officer, police chief, fire chief, director of public works. Specifically, director level is defined as a position by the mayor, is appointed by the mayor or a vote of a governing body, or appointed by the mayor and confirmed by the governing body. Has authority over the operation of the employees of a department, agency, or division of governmental entity. Why do we need this bill? Local governments across the state have found it difficult to recruit and interview qualified applicants because their application information is public. Applicants fear reprisal from the current employer if they aren't selected for the job. Also, others may be looking for the same position, and this be made known. Another county or city may hire this person. So several states bordering Tennessee have a similar law: Virginia, North Carolina, Missouri, Georgia, Arkansas, and Kentucky. This bill would support our local government officials by giving them the ability to hire the best. And with that, I'll stand ready for questions.
We do have someone here to give us some testimony. So without objection, we're going to go out of session and ask Deborah Fisher to please come step up. Please give us your name and who you're with. And you already know you have 3 minutes.
I'm Deborah Fisher. I'm Executive Director of Tennessee Coalition for Open Government that seeks to preserve and promote transparency in government. This bill would make confidential information around the hiring of a director of schools, a city manager, and other positions that require a governing body vote. I think this would be a very large change for communities across Tennessee that have long had open and transparent processes, especially for those positions. Under this bill, the local governing body would not even have a choice but to participate in the secrecy, even if they did not want to. The bill allows an applicant, it says that if an applicant requests his or her application to be confidential, the governing body must oblige. The bill allows the board to interview the candidate in executive session, but it says that the board must deliberate and vote on who to hire in a public session. But how are they going to deliberate if the names of the candidates are confidential until after the vote and only the name of the person they decide to appoint to the position? I think it would be a public meeting where members of a school board, for example, would have to refer to applicants as candidate A and candidate B and candidate C as they talk about their qualifications. And this kind of secrecy is not just awkward and confusing to impose on local governments governing bodies and communities, it breeds suspicion, frankly, and sometimes resentment and general questions about why so much secrecy. This has always been open in the past. I don't think they could even discuss the qualifications of the candidates in an open meeting, considering it would reveal information from an application. Finally, I have real concerns. I don't think the caption on this bill, which only opens Title 8, Chapter 44, the Open Meetings Act, is large enough to create an exception to Title 10, Chapter 7, Part 5, which is the Public Records Act. I think this is especially so because there is a specific provision in Title 10, Chapter 7, Part 5 that will remain in the code, even if this bill passes, that directly contravenes the bill you are being asked to pass. And that provision is 107503F, and it says, all records, employment applications, credentials, and similar documents obtained by any person in conjunction with an employment search for a director of schools or any chief public administrative officer shall at all times during business hours be open for personal inspection by any citizen of Tennessee. This bill, which would change the Open Meetings Act to allow interviews to be conducted in executive session, should not be allowed to also eliminate or neutralize an entire and specific subsection of the Tennessee Public Records Act. I think it would be legally confusing and confusing just to normal people looking at this as well.
I'm sorry, but your 3 minutes is up. Do we have any questions for our guests? Representative Salinas?
Yeah. So most of my experiences in public funded universities or research, because I'm involved in research, and I am sensitive to the fact that it can make some of these hiring processes hard and recruiting. For example, my boss at one point was recruited to another university, and they have a public process for that purpose, right? So, and it should be, because it is publicly funded. As awkward as it can be, our institution found out about it when we were working. It not only made it hard for that individual, but also for everyone working under them. So in your opinion, are we having a specific just carve out for government in this bill?
You're recognized.
Yeah, and I think, yes, and yeah, it is just for government, and it's for any position that a governing body votes upon. And it's the biggest problem we have with this bill is that it is so broad. The director of schools, the city manager are big positions with a lot of influence. And in Tennessee, that has generally been accepted to be an open process. The bill applies to anything that a governing body would vote on or a mayor would appoint, and has to be approved by a governing body. So, but it would just be for government positions. Those are the positions, when I talk to people in the public, that especially the director of schools position, people are very interested in that position, and there can be sometimes controversy over it. In this situation, you wouldn't even know who else applied or if anybody else applied, so.
Chairman Elder asked if this is something we want to push through now, or something we want to roll to the heel and pick it up next week, but I guess see if
We'll just,
members have
yeah.
questions.
Okay. You got a question for legal? Okay. Where at? Go ahead and ask. You're recognized.
Yeah, thank you, Madam Chair. Would this bill, would it open up Title 8 and Title 10, nullifying a provision in Title 10 of the Public Records Act?
Matt Mundy from Legal. The caption on the bill opens up Title 8 relative to executive sessions for consideration of employment by a governing body. I understand Ms. Fisher's concern. The question as to the appropriateness of a caption is usually delegated to the clerk of each house. But what I will tell you from Supreme Court precedent when it comes to captions that the caption has to be sufficiently accurate to give the reader enough information to anticipate what's going to be in the bill. And this is about executive sessions, and they want to have some confidentiality requirements, and they specifically cross-reference a provision in another title, and we do that frequently in bills that we draft. In this bill, this amendment has been approved by the clerk to be put on this bill, and so I don't have any issue with the caption.
One follow-up, please.
Yes.
Thank you, Madam Chair. Just say if us using a school board member for an example wants to reveal who applied for school director, would they be allowed to do that under this bill?
You're recognized.
I think, as I understand the intent, it seems like the executive sessions are for vetting applicants, and upon request, their application interview information would remain confidential. And then if they wanted to either take one or more people that made it through the initial executive sessions for consideration of final hire, that would go to the public meeting. And I think at that point, that information would become public. But if you were not chosen to either be confirmed at the public hearing or be considered at the public hearing, that information would remain confidential if at their request.
If there's no more questions, we'll go back into session, and thank you for being with us today. Do you have a follow-up or any more comments? Chairman?
Just one comment. I actually went through this process. We were looking for a chief financial officer for Blount County. We had numerous interviews. No one made requests for who applied. But if it had been reported that our number one candidate was available, then Mayor of Knox County, Tim Burchett, would have hired him without a doubt. So we actually, the mayor made the appointment. Well, it came before the county commission. We voted to engage this person while they were actually on a mission trip to Brazil. That's how critical. And this man served Blount County tremendously. He was a superstar, just recently retired. So with those comments, thank you, Madam Chair Lady.
Thank you. I recognize Representative McCollum.
Thank you, Chair Lady. Move previous question.
Previous questions been called. We're ready to vote. Please open the board for vote. Madam Clerk, all in favor, please signify by voting aye, or opposed, no. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 4 ayes and 2 noes.
The ayes have it, and you move on to full committee. We're out of time for today. I did not get to finish my calendar. We'll be back next week, and I hope you all have a good week.